I just tore mine up.
Robert, you broke it already.
Already? It didn't take me long.
Good morning. It is 10 a.m. on February the 12th, 2013. At this time, I'll call the meeting of the Department of Commerce and Insurance Board of Funeral Directors and Embalmers to order. And I'd ask Miss Lisa Mosby to call the roll, please.
Wayne Hinkle.
Here.
Tony Highsmith.
Here.
David Neal.
Here.
W.T. Patterson.
Here. Jane
Gray Sowell.
Here.
Robert Starkey.
Here.
Anita Taylor.
Here.
Mr. President, everybody's accounted for.
Thank you, Ms. Mosley. I'd like at this time to welcome Mr. David Neal to our board this morning. This is Mr. Neal's first meeting with us. Mr. Neal, I think you're familiar with everybody that is on the panel this morning, our legal counsel, Mr. Ribble as well. We welcome you to our board. Look forward to working with you in the coming year. Thank you. Give you the opportunity to look over the agenda as is presented today, and Chair will entertain a motion on that agenda once you have an opportunity to look at it.
Mr. Chairman, I move to adopt the agenda as presented. Second.
Motion has been made by Ms. Sowell, second by Ms. Taylor to adopt the agenda as presented. All in favor, say aye. Aye. Any opposed? Thank you. Next, we'll have the opportunity to review the minutes from the December 11 and 17, 2012 board meeting. I ask you to please do that now.
Motion to approve minutes as presented.
Second.
Motion has been made by Mr. Hinkle, seconded by Mr. Patterson to approve the minutes that as they have been presented. All in favor, say aye.
Aye.
Any opposed? Motion carries. Next item on our agenda today is to consider procedural aspects for the board for the year 2013. In years past, this board has operated under the Robert's Rules of Order, and we'll entertain discussion about that at this time or a motion.
Make a motion.
Second.
Motion has been made by Mr. Starkey, seconded by Mr. Hinkle for this board to rule by the Robert's Rules of Order for the year 2013. Any further discussion? All in favor say aye. Aye. Any opposed? Motion carries. Next item of business is our conflict of interest statements. I'll give you an opportunity. Those are in your packets. Give you an opportunity to look over those. Any questions or discussion about those? If not, by the end of the meeting, I would ask everyone to please sign those and pass those to Ms. Lisa, if you would, at the conclusion of the meeting. Board will now recognize Mr. Adrian Chick, Assistant General Counsel.
Good morning, Board. There was a hearing that was originally set to be heard today, but I've been able to negotiate an agreed order, and the agreed order provides for a civil penalty that is $1,000, which is actually a little bit higher than what the Board previously authorized, in addition to $200 in administrative costs. And as you'll see on your iPad, the factual allegations or the stipulations of fact would be that the respondent, he's a funeral director and his license had expired from June 30th, 2010 until August 30th, 2010. And during that period, he conducted, let's see, 1, 2, 3, 4, 5, 6 funerals. And there was also...
Mr. Chick, may I interrupt just a moment, please? Everybody on board with where we are? Is this,
Barlow?
it's taken to Mr. Barlow? Okay. Everybody up to speed where we are with Mr. Barlow? Okay, Mr. Chick, sorry for the interruption.
That's okay. And there was also in the original complaint an allegation regarding the respondent's mother, who is approximately 90 years old, and her license had lapsed, but after further discussion with the field rep that was out there, we determined that she had was not active and had no involvement. So as part of this agreed order, the complaint against her would be closed. So I'm presenting this to the Board and requesting that you approve this.
Make a motion that we accept your...
Second.
Motion has been made by Mr. Patterson and seconded by Mr. Hinkle to accept the agreed order as has been presented by Mr. Chick. Is there any further discussion? All in favor, say aye.
Aye.
Any opposed? Motion carries. Next, Mr. Chick.
Smith, if I may, I'll present to you the final order. Thank you, Board members.
Good job.
Chair now will recognize Mr. Ben McDonough, Assistant General Counsel, for legal report.
Thank you, Mr. President. Members of the Board, let me begin today, since today is the first meeting of the new year 2013. At our previous staff meeting with all the attorneys, they asked us just to reiterate the Open Meetings Act law and to make sure that everyone is aware and remembers that we would request that you not have any discussions between two or more board members. Once at least 2 board members are present and discussing an issue, it is considered to be subject to the Open Meetings Act, and we just request that members of the board not discuss any board business between each other unless you are here in the boardroom and discussing it out in public. And also they've also asked us to remind everyone that just be careful about whispering or talking amongst yourselves. during the meeting. It's not a problem with this board, but I just wanted to make you all mindful of that and just remind you since it's the first meeting of the new year. But with that being said, I just wanted to start the legal report. I have a previous complaint that came before the board, and I'll start with that one. It states that on it's complaint number 2011-01-0021. It states that on August 9th, 2011, this complaint was presented to the board against the respondent. A field representative carried out a routine inspection of the respondent's establishment on March 21st, 2011. This establishment is a crematory that contains both a human retort and a pet retort. The pet retort is located within 10 feet of the human retort, and the respondent uses the same processing station to pulverize human and pet remains following cremations. The crematory was previously granted an establishment license in September 2004 with the knowledge that human and pet cremations would take place there. The inspection conducted on March 21st, 2011 did not result in any known violations. And although there was no documentation showing a commingling of cremains from pets and humans, such a risk does exist when using the same processing station for both humans and pets. To update this case, the board initially asked for a consent order with a $1,000 civil penalty. After several stages of negotiations, the respondent has agreed to purchase and install a brand new processing station to be used in human cremations only. But the board must agree to rescind the $1,000 civil penalty, and the respondent would not admit to guilt in this case. And as your legal counsel, I believe that this is a proper agreement, as the respondent agreed to purchase and install a new processing station, which was the ultimate goal of the board in this case. And so at this time, I'm asking that the board support this agreed order with the respondent in this case, and that will allow us to close this matter.
So moved.
Second.
Motion has been made by Mrs. Sowell, seconded by Mr. Hinkle, to agree with the attorney's recommendation regarding this outstanding complaint. Is there any further discussion? I would have a question, Mr. McDonough.
Yes, sir.
And I know it's not the issue here, but I think it does pertain to the issue here. To our knowledge, is the pet crematory and the human crematory still contained within about 10 feet of each other?
I have no reason this time to believe that that has changed, but as you said, it's not related to this one so much as it's something that we can certainly look into in the future.
I understand that the processing station in question here, that this does settle that issue of this complaint. I just want to make sure that if this pet crematory and human crematory is in the same general location, that what we do today concerning the processing station does not have any effect on any outstanding complaint or any future complaint regarding allowing this processing station again to be placed within 10 feet of the human crematory. I hope you understand my question.
Yes, sir. And the wording in this agreement specifically states that this consent order will resolve all issues that are currently outstanding. This is the one that's currently outstanding. This is the only one we have against the respondent. So this consent order would resolve this matter.
This matter only.
This matter only. No future issues or anything like that. I would never agree to resolving an issue in the future, any sort of violation in the future. So.
Is there any further discussion?
Well, the further discussion would be, was this crematory, how long has it existed?
They've been licensed based on what I know. They've been licensed since 2004. That's when they initially.
Has it always been a pet crematory there too, which I understand?
That's what they're alleging that the board knew about it back in 2004, and that's the extent of what I know as far as that goes. Yeah.
Well, the reason I'm asking that question is because if the law changed after that fact, and they have to be separated, I think is my question.
Would they have to be separated
Yeah.
if the law changed?
Well, the law was changed
Yeah.
since they did it, see?
Right.
So,
That's something that I would have to look at a little closer and see for sure.
well, with the president's statement, I don't think it's quite fair to say any other issues when they've operated, my understanding, since 2004, theoretically legally, and then now they're illegal because of the law changing. So I don't think it would be fair to go back with this one issue on the other issue unless they've been told, well, you need to put a wall in between or something.
Well, I can tell you that our field representatives, anytime they perform an inspection of an establishment, that they will make sure that the law that is currently in place will be upheld. They will note that in their report, any sort of violation that they see with the current law, and then at that point it's up to legal counsel to make the determination about whether or not we can move forward on those violations. So, and they will have plenty of constitutional protections in place to provide for the the safety of their operating license. So.
Any further discussion?
Does anyone know if they put in the new process installation?
They have not yet. Part of the agreement is that they have 90 days from the date of the agreement, which will be today, the 12th. They'll have 90 days from today to install it. Based upon my discussions with their attorney, they should have it done within 60 days, but we typically give people about 90 days to be able to follow the consent order that they've agreed to in a case like this. So we will send a field representative out to make sure that they have followed through within the 90 days.
We have a motion on the floor and a second. All in favor, say aye. Aye. Any opposed? Motion carries.
And Mr. President, if I can get your signature, okay?
Yes, sir.
Now we'll continue with the legal report. Number 1 is case 2012020691. Number 2 is case 2012020692. Number 3 is case 2012020693. And case number 4 is case 2012020694. On September 18th, 2012, the Funeral Board received a complaint alleging that the respondent number 1 had conducted embalmings for respondents number 2, number 3, and number 4 without being licensed by the state of Tennessee as an embalmer. The complainant failed to provide any evidence or documentation to support the allegations. In response, we received no response from respondent number 1. According to respondent number 2, respondent number 1 was a longtime part-time employee of respondent number 2 for 20 plus years. Respondent number 2 utilizes the services of Edmund Ford for embalming purposes and has done so since 1996. Respondent number 1 dressed decedents, worked under the direction of Edmund Ford, and drove for the establishment. Respondent number 3 states that respondent number 3 uses the services of Willie Lumpkin and Brittany Barlow for embalming services. Respondent number 3 has never personally met respondent number 1, but is aware of who he is through other associates. Respondent number 4 states that respondent number 1 does not provide embalming services for respondent number 4, but has assisted with dressing and casketing for a short time while another employee was out of town. Respondent number 4 states that complainant was in a relationship with respondent number 1 and that respondent number 1 decided to end the relationship. The complainant was later arrested for assault and vandalism toward respondent number 1, and the complainant has done everything to wreck the marriage and business relationships of respondent number 1. With respondent number 1, we found no prior complaints. With respondent number 2, we found 2 closed complaints and 1 open complaint. With respondent number 3, we found 2 closed complaints and 3 open complaints. And with respondent number 4, we found no prior complaints. And you can see a listing of all the prior complaints against the respondents there before you. And we are recommending for respondent number 1 a letter of warning regarding responding to pending complaints. And we're recommending that the cases against respondent number 2, number 3, and number 4 all be dismissed.
Respondent number 1, no response.
No response.
It says on the number, when you list the complaint number, it says funeral director. Now, over in this, it's talking about that individual number 1 being an embalmer.
Let's see.
Where the complaint number is listed, it says funeral director. Then we get over on the next page under the complaint.
I think that was
Respondent number 1 is, it says he's an embalmer, he or she is an embalmer.
I think that was a typo on that.
Which is, what license does the person have?
I don't know that he has a license. I think that's she's claiming, the complainant's claiming that he was doing all this activity without being licensed to do so, but I believe I accidentally put funeral director in there, but he is not licensed as either an embalmer or a funeral director. I think he was a funeral assistant, and I think that's what I meant to put in there.
My hat's off to you for sorting all this out.
Thank you.
It appears the complainant is accusing respondent number 1 of being an unlicensed individual embalming bodies.
That's correct.
It appears establishment number 2, establishment number 3, and establishment number 4 all say that that is not the case. He does not embalm for them.
That's correct.
Was there a reason for number 1 not responding?
That I'm not aware of. That's why I wanted to send the letter of warning in this case.
Why would there not be a penalty, $250 for not responding?
Just because I believe that there's no credibility to the complaint, and if I'm going to dismiss the other 3, then I thought we should at least send them a letter of warning, letting them know that in the future that they needed to respond to any sort of complaint against them.
Motion to accept council's recommendation.
Second. Now, what, just a minute.
Go ahead.
Motion has been made by Mr. Hinkle and seconded by Ms. Taylor, and now we'll have further discussion.
Jump to the gun. Well, on the history here of respondent number 2, one of the previous complaints was that they allowed embalming by an unlicensed person. These are separate establishments?
Yes, ma'am. I will add that, I'm not aware of what the evidentiary support was for the previous complaint, but there was no support, any evidence of any wrongdoing in this case. They just alleged that this individual was embalming without being licensed.
All consent orders have been paid except for the last two that's still open.
Yes.
Respondent number 4 did not respond, but,
Respondent number 1.
well, no, I'm sorry. Respondent number 4 had no prior complaints,
That's correct.
but respondent 2, 3, and 4 all responded.
That's correct.
These open complaints on respondent number 3, why are they still open? They have not.
I can't say for sure. I don't know that all of them have been.
Well, 3 of them are open, 2 are closed, 3 are open. Or the previous complaints on respondent number 3.
I can just tell you at this point that.
Of course, one of them's in December of last year.
Yes.
Indicate that they haven't complied with the penalty that was incurred for those complaints.
It's just evidence that they're still open. I mean, I'm
not trying to be difficult, but I don't know what that means.
Well, I understand. All I'm saying is that they have 3 that are still open, and we haven't closed the case yet, and that's really, the extent that we can
If that's
discuss
all
those
you're
other
allowed to
cases.
say.
I think so. Yes, ma'am.
But they can't pay until you close the case, right?
They haven't signed the consent order or the civil penalty
Okay.
together, so at this point, those cases are still open.
And they have, is it not customary they have 30 days once they receive the,
Typically, and it could be that those matters are in litigation at this point.
None of those matters pertain to this matter, though.
No, they do not.
Thank you.
Any further discussion? This motion on the floor has been duly seconded. All in favor, say aye.
Aye.
Any opposed? Motion carries.
Number 5 is case 2012023-681, and number 6 is case 2012023-682. The state medical examiner filed this complaint, and on August 30th, 2012, the medical examiner signed a pending death certificate for the decedent, Charles Lewis Ray. The medical examiner released the document to the respondent along with the decedent's body. The medical examiner's office received a copy of the official filed death certificate on October 30th, 2012, and this document was filed with the Office of Vital Records. However, this document was not the original document signed by the medical examiner. The medical examiner states that the document in their possession is not the original, and the doctor's signature is not her signature. In response, respondent number 6 answered the complaint on behalf of both respondents. Respondent filled out a practice sheet rather than the original document that was signed by the medical examiner. However, upon reviewing the practice sheet, the respondent states that everything came back blurry and off-center. This document was then sent as the official death certificate rather than the original document provided by the medical examiner's office with the doctor's original signature. The respondent received this complaint, then reviewed the files in question and found the original death certificate with the doctor's signature caught between two documents in the file. The respondent states that this was an error and they did not mean to forge the doctor's signature in this case. As far as the prior history, with the respondent number 5, we found 4 closed complaints, and respondent number 6, we found no prior complaints. And for respondent number 5, we're recommending a consent order with a $1,000 civil penalty and authorization for a hearing. And respondent number 6, we're recommending a consent order with a $500 civil penalty and authorization for a hearing.
Respondent states that this is an error and did not mean to forge the doctor's signature.
That's correct.
They signed.
That it wasn't a prescription.
So they actually signed
Is it
the
proper
medical
for,
examiner's name?
Yes. The medical examiner signed the original one, obviously, and then sent that to the funeral establishment. And then when they were attempting to, I guess, fill out the documents and print everything off, then, or I guess it came back blurry for some reason, and she then filled out another one and went ahead and signed the medical examiner's name on that one.
is it proper for respondent 6 to respond for respondent 5?
Well, respondent, let me see here. Respondent,
So that they answered the complaint on behalf of both?
because one was the manager and one was the establishment, and so she was simply just responding on behalf of both of them.
And number 6, respondent number 6 is actually a funeral director.
That's correct.
Wouldn't it have been much easier to take it back to the medical examiner's office?
Probably now.
Hindsight says she should have. I make a motion, we accept the council's recommendation.
Second.
Motion's been made by Mr. Starkey, seconded by Mr. Patterson to accept council's recommendation for both items number 5 and number 6. Any further discussion? All in favor say aye.
Aye.
Any opposed? Motion carries.
Number 7 is case 2012023811. This complaint was filed against the respondent by a consumer. On October 16, 2012, the decedent passed away following open heart surgery and was taken to the respondent funeral establishment. On October 17, 2012, the decedent's husband and children went to make final arrangements, but there was an issue obtaining the insurance policy, so the arrangements remained incomplete. On October 18, 2012, the decedent's family went to the funeral establishment to fix the decedent's nails and hair, and the family was led to the chapel where the decedent was on a table with a sheet draped over the body. The drain alley still had blood puddles in it, and there appeared to be blood clots hanging out of the drain hose at the foot of the table. Furthermore, the only place where the family could wash up was at the public restroom. On October 19, 2012, the family arrived 2 hours prior to receiving friends. There was very minimal makeup applied to the decedent's face, and there was no mascara. The lipstick stopped at the nose line, and dark bruises were evident. There was no makeup applied to cover the trauma to the decedent's neck. There was blood-soaked cotton covering the site where the blood was drained. There was a suture lying on the decedent's blouse. No undergarments were under the blouse. The cotton covering the surgical incision was very visible. The decedent's underwear was not pulled up completely. The daughters asked that the makeup be reapplied, and the complainant states that they killed at least 6 gnats that came out of the casket during the viewing. The daughters applied mascara to the decedent, and the employee didn't even offer to provide the service, and a niece went to a local store to purchase a scarf to cover up the decedent's neck. The funeral home was too warm, and the decedent's color actually darkened in the 6 hours while the family was present. On October 20th, 2012, there was very little organization from the respondent. The employees almost pushed the casket off the stand as they were moving the casket from the viewing room to the chapel. There's no one directing traffic, causing the daughters to be the last in line to the cemetery. Also, the complainant touched the decedent's body and found it to be soft, which she thought was odd for a body that had been embalmed. In response, respondent states that on October 17, 2012, the decedent's family met with the respondent's employee to discuss final arrangements, but they were not sure how they planned on paying for the funeral until they located an insurance policy later that afternoon. On October 18, 2012, the family arrived to fix the decedent's hair. The decedent was placed in the chapel because the respondent believed it was a better environment for the family to provide hair care. Respondent employee explained to the family that the decedent was in the chapel and that the body was covered with a sheet. The sheet was placed to cover the drain tube, and the respondent admits that they should have lifted the sheet to see if the drain tube was dirty. On October 19, 2012, the respondent employee did not provide the initial cosmetics application. However, she believed that the person who did cosmetics did a good job. The employee wishes she had looked over everything to make sure all the details were properly addressed. The family said that they were not happy with the lipstick, so the employee offered to try and fix that. While the employee was working on the lipstick, the family asked that she cover the bruises on the decedent's face as well. The employee states that this was a difficult case as the decedent's entire arm was exposed due to her wearing short sleeves. The employee was unaware of the difference in color in the hand and the arm, but stated that the difference could be due to the amount of makeup applied on the arm. The employee did not offer to apply mascara to the decedent as no one asked her to do that, and she would have gone out and purchased the scarf if the family had made her aware of the condition of the decedent's neck. The family gave the employee very specific instructions that they would view the decedent's body and then close the casket for the funeral service as the decedent had requested. However, the family asked the employee to leave the casket open as they informed her that the decedent looked so nice. As for the temperature in the establishment, the employee states that she was unaware that the family was uncomfortable and with the temperature in the establishment. On October 20th, 2012, when moving the casket to the chapel, the employee was unaware of any issues during the transportation, and nothing out of the ordinary of moving the casket had occurred. As for the transportation to the gravesite, the employee states that some family members preferred to walk while others drove to the gravesite, but they allowed any family member who wished to drive to the gravesite to park their cars behind the hearse. The employee states that she worked very hard to address the concerns of the family and asked on numerous occasions whether the family needed any assistance. However, she regrets that there may have been some issues with leakage from the decedent's body caused by the presence of edema. Also to note, on November 19, 2012, the board received a letter from the manager of the respondent establishment stating that they were refunding the family $1,365, which was the total cost of embalming and dressing the decedent. We found a history of 3 closed complaints, none related, and we're recommending a letter of warning in this case.
Were these people pretty well satisfied with what you tried to do for them after?
As far as the refund, I believe they were, yes.
Make a motion, we accept council's recommendation.
Second.
Motion made by Mr. Starkey, seconded by Mr. Neal to accept council's recommendation. Any further discussion?
I will certainly vote for that, but this is horrible to listen to this. I can't understand people. having no more respect than this. I just don't see how they could be in business.
I agree with Ms. Howell.
I'm sorry.
I do agree.
It's embarrassing to have to sit here and this, and I don't know who these nice people over here are, but if they're consumers or you're a consumer, all most of us have been around for a long time. But I just sit here and hear this is just, it's appalling.
Again, I agree with Ms. Howell. And I would say that the disagreement about the cosmetics, as we all know, a lot of times that is in the eyes of the beholder, but yet I see no excuse for this unsanitary environment that these hairdressers and manicurists had to work in. That is certainly not professional conduct. Had an inspector gone into their preparation room on a routine inspection and found these violations with the unsanitary environment, I think there would certainly be a complaint filed.
Or if they'd seen the in the chat.
Well, I realize that the Federal Trade Commission or any other entity has anything to do with the licenses and charges that people place on those services. But I don't believe I've ever seen this amount for embalming, dressing the body on watch it. And if anybody ever deserved a refund, these people did.
I agree.
That's,
You know, and
this
there's-
is an extraordinary amount of money
They
for
can,
that service.
you know, and some of these things, you know, that's on here, I mean, this moving of the casket and, you know, that type of thing, you know, those things are something beyond anybody's control. And this funeral procession in the back of the line and all that, you know, most funeral processions, first of all, you've heard my say about a funeral procession. I won't go in the most dangerous thing you ever done, because there's a lot of people out there that sees the first 2 or 3 vehicles, and the next ones they don't pay attention to. And some establishments has these little flags and stuff, but the one thing that some of them decide to walk, so it couldn't have been that far. But again, this lady may not have been able to walk that far. And you've seen instances where y'all try to get people to put the family in the cars and that, and the next thing you know, you got them scattered all over the place because they just jumped the car. But some of these things are. I agree with Jane. Some of these things that should not have happened as far as, you know, but now the family seems to be satisfied with the refund.
I believe the fact that the respondent provided a refund for the embalming services certainly went a long way in our determination of
Yeah, I understand that.
issuing a letter of warning instead of recommending a letter of warning instead of a consent order.
Has there been any contact with the family that they were, and I'm not going to say this, happy with the final results of the refund, or did they just take it and say, you know, I understand that sometimes, and you folks deal with them all the time, things just don't work out. And you can't, I'm going to say this, and I shouldn't say this, but you can't make everybody happy sometimes. You do the best you can do to take care of the family and family limit. That's what bothers me, just like James talking about. I mean, the way they handle the body is what bothers me. But,
I thought we had some correspondence from the family, but you know, if it's something that you all would like to go ahead and agree with the letter warning with the idea that I contact the family and make sure that they were satisfied with the refund. And I thought they sent us a letter or had a phone call or something like that, but I would like to call them up just to make sure that they were fine with that. And if they were not satisfied with it, then I'd be more than happy to bring it back before the board.
somebody, you all need to amend the motion and,
Yeah, we need to amend the motion.
Well, there's a good bit of not just negligence, but total lack of properly taking care of this body. And
I asked a question, would it be proper for us to table this one?
If that's what you feel is
Okay,
proper in this case, we could do that.
that would be up to whoever made the motion.
As a funeral director, the only issue I have with this whole thing here, because in 50 years I've seen families complain when I knew one reason they were complaining was because the insurance policy was no good.
Yeah.
And, you know, the embalming table with blood on it is unexcusable.
I agree.
We roll the body. When we have an outside hairdresser that's not our normal one, and we have other bodies in the morgue, we move it to another room. I don't move it to my chapel, but I move it to a visitation room.
I agree.
And that's where they do their hair. So
No problem with that.
everything here is within bounds to me.
not
With-
if you just got a sheet on them and no underclothes. And then when they do have them on, they're not even properly, they didn't put the underclothes on them.
Well, that's still, you know, at the time the hairdresser, maybe the family hadn't brought the clothes yet. We don't know the whole circumstances here. Now, we put a gown on somebody. If a lady's coming to be, hairdresser's coming and the family hasn't brought, of course we keep underwear there, but we put a gown on the person if she's not dressed. But I don't know the particular circumstances of this funeral home, but I still can't find that other than the table. I mean, I've waited on a lot of families and thought everything was perfect, and in the family's mind, nothing was perfect, you know, and I know that I did the best I could. Makeup, you know, always, some people think they ought to have had more, some people they think they ought to have had less, so, but, you know, the temperature, you know, the air condition might not have been working, you know, in the family's eyes, that's what caused the body to, we weren't there, we don't know. The bloody table, that's, you know, should have been changed. Years ago, we had a complaint to the board on a cremation. The family wanted to see it, so we put the a gown, underwear, the gown on the body, and the family was supposed to come. Well, they brought about 30 other people with them. The family didn't complain to the board, and we had her on the table because back then we didn't have cremation containers, and they didn't want a casket. But they wrote us up because we had her on a gurney. Well, it's a dressing table, you know, or they complained, but it was a friend of the family thought it was awful, you know, that she wasn't dressed. The family didn't want her dressed. So sometimes these things are the opinions of others that don't know the going on of the business. Now, I'm not trying to, you know, I don't know who these people are, but I can't find that much fault other than a dirty table here. I mean, these things could happen to any funeral home and on any given day. So, I mean, I can see no reason to table this thing. I mean, I mean, in all fair respect to everybody else on the board, I think we ought to just,
I'd like to see a penalty applied for the unsanitary environment, as Mr. Starkey has referenced. However, we have a motion on the floor to accept council's recommendation, and that is before an amendment of any kind is made. Procedure would be to vote on that motion first. Is that not correct, Mr. McDonald?
Yes, that was the letter of warning.
Okay. There's a motion on the floor to accept councilman's recommendation with a letter of warning. It's been duly seconded. The first order would be to vote on that motion. All in favor, say aye. Aye. All opposed, no. No. So Ms. Mosley, let the record show that they were, I think, let's have a roll call vote, please, ma'am. This is regarding item number 7.
Wayne Hinkle,
No.
Tony Highsmith,
No.
David Neal,
Yes.
W.T. Patterson,
Yeah.
Jane Gray Sal,
No.
Robert Starkey,
yes.
Anita Taylor.
No.
The motion fails. So we're back to reconsider item number 7.
Question, are we going to make a motion to add a penalty?
We will move at the will of the board. As of right now, there's no action taken. So we're open.
I moved a letter of warning regarding, I had to put this.
Ms. I, would it be of help to you if Mr. McDonough restated his,
Yeah, do that.
about, after the letter of warning, you had mentioned there could be an amendment. There's not an amendment now because we haven't taken any action, but would you restate your, what you had agreed to do besides the letter of warning?
I had agreed that if you all wanted to approve the letter of warning with the idea that if I contact the family and you know, they approve of the action of the funeral establishment of refunding the money, then I could follow through with the letter of warning. But in the event that they're not satisfied with the $1,300 refund, then I could represent the case next month.
That wouldn't require tabling it then because it's got the aspect.
Right.
Motion to approve councilman's recommendation as he's just stated it.
Second.
Ms. I, you had the floor. Will you
Oh,
finish?
I'm sorry.
Yes, that's fine, but I would like to add there be a $500 penalty for unsanitary conditions and,
Well,
let's just leave it at that. Can we do that?
We can't send a letter of warning with a civil penalty. I mean, it's either a consent order.
We can't divide it.
I don't think so. I think it's,
We'll just leave it at that. We don't worry about
So, Mr. Hinkle, your motion stands.
My motion stands.
And Ms. Taylor, your second.
Second.
Okay. Mr. Hinkle has made a motion. Ms. Taylor has seconded to be a letter of warning to the establishment and also a letter sent to the family to see if they are satisfied with the refund of $1,365. With that motion being made and seconded, Ms. Mosby, I'd ask for a roll call vote, please.
Wayne Hinkle,
Yes.
Tony Highsmith,
No.
David Neal,
Yes.
W.T. Patterson,
Yeah.
Jane Gray Sal,
it. No.
Robert Starkey,
Yes.
Anita Taylor.
Yes.
Ms. Mosby, it appears that the motion is passed, correct?
Yes.
Number 8 is case 2012024011. On April 23, 2012, a field representative conducted a routine inspection of the respondent establishment. A cremation authorization form signed by an authorizing agent or agents, also signed and dated by the funeral director, must be in all the cremation files and retained at the funeral establishment. 3 files for Ethel E. Johnson, Kenneth L. Weiser Jr., and William Minnick did not contain the form cremation authorization form. On the statement of funeral goods and services selected, the name of the funeral establishment is not consistent with the name used when this establishment was licensed with the state of Tennessee. All contracts must use the license name or apply for a name change with the state of Tennessee, the Board of Funeral Directors and Embalmers. The current Embalmers license of one individual is not available for inspection. Unclaimed cremated remains on the establishment cremation authorization forms must read 180 days instead of the 120 days currently shown. Under alternative containers on the casket price list, the Stratus with no interior offered to the consumer is listed for $450. However, on the establishment's statement of funeral goods and services selected, the consumer is charged $545. This was evident in 2 contracts for Alvin L. Brown and Kenneth L. Weiser Jr. Also, the statement of funeral goods and services, the merchandise and its description must be shown on the contract before the consumer signs the contract. 3 files for Dorothy M. Dixon, Ann M. McRae, and Patricia A. Kelty did not contain this information on the statement of funeral goods and services selected. In response, the respondent states that it was an oversight not to include the properly executed cremation authorization forms in the files as required by law. The respondent provided copies of the properly executed forms. The allegation that the statement of funeral goods and services selected of the establishment does not match the name provided on the establishment application form is accurate. The respondent did not realize that the statement of funeral goods and services selected printed the name in a manner inconsistent with the name on its license. This matter has been resolved. As for the embalmer's license not available for inspection, this individual no longer works for the respondent, and that employee's embalmer's license was inadvertently left on the wall during the inspection. Also, it was an oversight to state 120 days rather than 180 days on the cremation authorization form. This oversight has been corrected, and the charge of $545 on the statement of funeral goods and services selected includes a $95 charge for a liner. The Stratus with the interior lining priced at $545 is included in the contracts and authorized and signed by the purchaser of each contract reviewed. As for the description of merchandise being placed on the statement of funeral goods and services selected prior to the consumer signing the statement of funeral goods and services selected, the respondent states that this was an oversight and they are not aware that the casket name and description was not on the statement of funeral goods and services selected in 3 instances. We found a history of 1 closed complaint, and we're recommending a consent order with a $500 civil penalty and authorization for a hearing.
Make a motion that we accept his recommendation.
Second.
Motion been made, Mr. Patterson, second, Mr. Hinkle. Accept council's recommendation. Any further discussion? All in favor say aye. Aye. Any opposed? Motion carries.
Number 9 is case 2012024031. On August 1st, 2012, a field representative conducted a routine inspection of the respondent establishment. All cremation authorization forms must be signed by an authorizing agent or agents and a licensed funeral director and maintained in the files of the establishment. However, in 2 instances, regarding Don A. Baldwin and Robert Leo Fitzpatrick, the respondent failed to retain this form. The current funeral director's license of one individual was not available for inspection. The current embalmer's license of one individual was not available for inspection. As for the general price list, the alternative container for direct cremation disclosure is not correct on the general price list, with that being offered to the consumer. Also, under direct cremation with wood grain exterior fiberboard container is not listed on the general price list as an alternative container. And on the casket price list, it states that on the general price list, immediate burial with casket purchased from the funeral home. This price of option A plus cost of casket selected, the low to high end range price is inconsistent with the casket being offered to the consumer. We received no response in this case, and we found a history of 1 open complaint and 2 closed complaints. And we're recommending a consent order with a $500 civil penalty plus $250 for no response, for a total civil penalty of $750 and authorization for a hearing.
Motion to accept recommendation.
Second.
Motion made by Ms. Taylor, seconded by Mr. Neal to accept council's recommendation. Any further discussion? All in favor say aye.
Aye.
Any opposed? Motion carries.
Number 10 is case 20120248081. On August 15th, 2012, a field representative conducted a routine inspection of the respondent funeral establishment. The respondent failed to obtain and maintain a copy of the most recent license of the crematory utilized by this establishment. The respondent failed to sign the cremation authorization form in 2 instances, as they were not signed by a licensed funeral director in the case of Irene Bradford and Worley Minton. The respondent failed to provide the reason for embalming in 9 statements of funeral goods and services selected for Lucille Kefauver, Bill Correll, Danny Dickey, Christine Buck, Monty Kinley, Gail Maupin, Edith Bridger, Penny Sue Ferris, and Mildred Cannon. Also, the respondent permitted their general price list, casket price list, outer burial container price list, statement of funeral goods and services selected, which were likely to be viewed by the public, to refer to the funeral establishment by name other than the exact name listed on the establishment application approved by the board. In response, the respondent admits to failing to obtain an updated copy of the crematory license and states that their crematory is not on the premises of the funeral home, and they had yet to receive an updated copy from the crematory office. Respondent admits to failing to sign under licensed funeral director on 2 cremation authorization forms, and respondent states that they failed to provide the reason for embalming on 9 statements of funeral goods and services selected, and will diligently try to correct this error in the future, but they were in no way trying to be deceptive. As for the documents with a different establishment name, the respondent states that their contract did not have the full changed name on it due to the fact that their accountants make the contracts for them, and they did not provide the respondent with the corrected documents. We found a history of 3 closed complaints, and we're recommending a consent order with a $750 civil penalty and authorization for a hearing.
Well, they're certainly consistent about not having the crematory inspection. I mean, this seems to be, they haven't got the message.
Establishment states that he has not received that information from the crematory. It appeared to me he needs to change crematories. That's beside the point.
Well, and the crematory accepted an authorization form without signatures.
The violations.
Is it possible that when they omit signing the cremation authorization forms, and then the inspection takes place, and then they sign it before they get to the crematory, or the crematory possibly points it out to them, but by that time the inspection has already taken place.
It's certainly possible, but they gave us no reason to believe that that's what happened.
Why would the crematory accept one that hadn't been
Right.
signed? I sure would. I don't think our crematory would do that.
Motion to accept council's recommendation.
Second.
Motion been made by Mr. Hinkle, seconded by Ms. Taylor, to accept council's recommendation. Any further discussion? All in favor, say aye. Aye. Any opposed? Motion carries.
Number 11 is case 20120242121. On September 10th, 2012, a field representative conducted a routine inspection of the respondent establishment. The respondent's establishment license expired on June 30th, 2012, and was not renewed until August 27th, 2012. During this time, the respondent conducted 34 funeral services. Current license for the crematory utilized by the respondent was not available for inspection. And following the review of several funeral files, it was determined that 4 of the files lacked a cremation authorization form, specifically for Robert B. Thomas, Gladys Wiseman, William Payne, and Timon Rice. In response, the respondent apologizes for failing to properly renew their establishment license. They take full responsibility for this and state that this was not a normal occurrence in their business. As for the 4 files lacking cremation authorization forms, respondent states that the names listed do not correspond with their client list of January through August 2012. We found a list of 13 closed complaints, one of those being dismissed, and we're recommending a consent order with a $3,500 civil penalty and authorization for a hearing.
Question, what does that mean? The 4 files lacking did not correspond to anybody they had buried, so where did those names come from?
Well, our field representative looked in their files, and that's what they found. They're alleging that that doesn't correspond with their list, but I would say that if we found something in their files, I don't know why.
How would we find it if it wasn't in there?
Right, exactly.
Would that list maybe have come from the local health department? Cremations that have been registered through them?
That's possible.
Field representatives sometimes go to the health department, pull the list of cremation authorizations that have been issued in that county for a period of time, cross-reference that to the funeral homes. Could possibly explain looking for those 4 names.
When they say that the cremation form was not in that file, do they have to produce that cremation authorization form?
It does look like they went through the health department files and compared them to so it appears that's what they did, what the field representative did.
So apparently these people were serviced after August then? If they couldn't find it if the establishment couldn't find them on their client list from January to August, then I would assume that they were from August through December maybe.
Well, see, this was, the complaint was September 10th. So
Okay.
it had to be before then, so, I mean, maybe the health department was wrong, you know. I mean, it looks like they would have had something in their files.
What if they're on the list that's sent to the health department by the funeral home? The monthly report? Is that where
Unless they pull somebody else's monthly
by the
report.
funeral home?
Or on the list where the health department receives the $25 and issues the permit.
Permit, yeah.
Yeah.
It just appears that the funeral home can't find 4 files.
Right.
Yeah.
I wonder.
I'm gonna make a motion to accept council's recommendation, because this civil penalty will make somebody find some files, I guess.
Second.
Motion has been made to accept Mr. Hinkle's. Motion been made by Mr. Hinkle, seconded by Ms. Taylor to accept council's recommendation. Any further discussion? All in favor say aye.
Aye.
Any opposed? Motion carries.
I think sometime we need to get these people to come up here and explain all this.
I think when they
Well,
get,
now, how are we gonna know that they have, where are these 4 people?
4 files.
The 4 files?
4 people to cremate.
These were people that were serviced by the funeral establishment. These are records that our field representatives found, and the,
But there's no cremation authorization.
they did belong in their files. And that,
I mean, I don't know what to, I mean, we're
Can we?
sending out a consent order with a $3,500 civil penalty on it.
What will happen, Ms. Sal, is either this respondent will pay that consent order and agree that they violate the law and they'll pay it. If they absolutely think that those 4 files were not theirs, then they're not going to pay it, and in some future hearing, in a formal hearing, then it'll be the state's responsibility to present beyond, or present evidence that the files weren't there.
Is there a follow-up inspection?
But we have to be very careful that we don't harass the people.
Well, everybody harassed. I don't want to be harassed.
The,
But it looks like somebody can check and see it.
I mean, we can check them for, if the board approves this consent order, which this one of
Which we just did.
just did. So if they sign it and pay the money, then they've agreed to the violation. If, I mean, we can certainly go back and do an inspection, but that's what they will pay to, they'll say, they'll fess up and say they did wrong, and that's what they'll pay for their mistake. Now, if on the next inspection there's something wrong, they'll be due complaint over.
If they pay the consent order, $3,500, the civil penalty, $3,500 in the file, they'll just pay the penalty and move forward. The biggest part of that penalty is consistent with the violation of the 34 funerals being conducted without being properly licensed.
Have they paid their license and with the penalty?
Yes. Their license was reinstated in August, I think.
Yeah.
Reinstated.
They renewed, they met the requirements to renew it on August the 27th, so you had almost 60 days they were unlicensed.
and if you look at their history, it's like the last thing happened in 2005, and it was dismissed.
Yeah, I went back up through there. They had several things, but a bunch of things were letter warnings and dismissed.
Any other discussion involving item number 11? I know we moved to item number 12.
Thank you. Number 12 is case 2012024141. On September 14th, 2012, a field representative conducted a routine inspection of the respondent establishment. The respondent's establishment license expired on August 31st, 2012, and was not renewed until September 14th, 2012. During that time, the respondent conducted 3 funeral services for Lucian F. Key, Alexander Wiseman, and Rakisha D. Jones. Also, one employee's funeral director's license was not available for inspection. The respondent permitted signage that was likely to be seen by the public to refer to the funeral establishment by a name other than the exact name listed on the establishment application approved by the board. The respondent's cremation authorization form stated that human remains may be interred, entombed, or inurned by the operator of the crematory facility if the human remains remain unclaimed after 120 days. However, according to statute, that must state 180 days. The respondent's latest inspection report of the crematory utilized by this establishment was not available for inspection. As for the general price list under direct cremation, the high-end range is inconsistent with the casket price list, and also on the general price list under direct cremation with alternative container, cardboard. This is inconsistent with the casket price list. And the file of Joyce Dupree failed to contain a cremation authorization form signed by a licensed funeral director. The respondent provided documentation showing that all these violations had been corrected, and the one violation disputed, the respondent states that their establishment did not provide services for the decedent, Joyce Dupree. We found a history of 2 closed complaints and 3 open complaints, and we're recommending a consent order with a $2,000 civil penalty and authorization for a hearing. And this is a different establishment than the previous one.
Yeah, but you still got 2 in a row that supposedly didn't bury the person or cremate them. So there's something amiss here.
I was going to say, we got another floater here somewhere, a tile problem.
Well, no, they could have been transferred to another funeral home. Could have picked them up. Because if you...
Well, though, if they're getting this from the health department's, I don't know if it's in the same county, but there's something amiss. Where this funeral home said we didn't handle her service.
If you pick them up, if you pick the case up,
For another funeral home,
No.
but didn't put it down.
the family calls you, you pick them up. In the midst of making arrangements, they change funeral homes. Wouldn't you still have to go on your report because you picked the case up
I don't know.
and you filed a death certificate?
Yeah, but you wouldn't be paying a $25 crematory fee.
That's right, that's true. If you weren't cremated.
Your recommendation is based on of course, the 3 funeral services and then the 4 TCA and the 2 rules violations.
That's correct.
Motion to accept council's recommendation.
Second.
Motion by Mr. Hinkle, seconded by Mr. Patterson to accept council's recommendation concerning item number 12. Is there any further discussion?
I would also like to add that in reviewing this file for number 12, that they did look at the health department logbooks, and it was signed off by the manager of the funeral establishment.
Mr. Hinkle, does that change your motion in any way?
No, sir.
Mr. Patterson? Any further discussion?
Yes.
Ms. South?
What? Well, if it's on the file by the health department, in the health department file, and the funeral signed on it. Now, they say they didn't do this. What's the problem here? Does this create another situation? If they're denying that they did this?
Well, as Mr. Gripple stated before, that in the previous case, you all elected to send a consent order and with $3,500 civil penalty, and if they decide that they're not going to pay it because they didn't do those cases they're claiming, then they have the right to come before the board and make that argument. But our evidence suggests that they did do that, and the health department logs have the signature of the funeral director, that's the manager. Well, I'm not going to say he's lying,
Well,
but
the evidence appears.
shows that he's got an inaccurate memory when it comes to these cases. So,
But again,
And the civil penalty recommended is what?
$2,000.
$2,000. And that's based on TCA rules violations and 3 services that was conducted.
it takes that into consideration. It also takes into consideration the previous previous complaints.
They've got $3,000 worth of civil penalties open at this time already, and they've already closed a $2,000 penalty. So I guess that says if you can afford to pay the penalty, just don't worry about your files. Don't worry about keeping up with your files. Just pay the penalty and move on. But those are pretty steep fines.
Well,
But you'll be
now we're
back.
in discussion. Can we ask that they appear before the board and explain this?
I mean, I guess you can
Show
always.
evidence that they did not do this.
No, I mean, I think because of the fact that they have the right to a hearing, then I think in that case, I don't think you have the right to call them before the board.
We can't call them to the principal top.
I don't think in this case, I think that you would have your opportunity to if it went to a formal hearing. In that case, I think the problem is that there's a complaint open against them, and then they would come before you if you asked them to come appear before the board. And then if it goes to a formal hearing in the future, one can make the argument that the board would have to recuse itself as a whole.
And I think that was the reason that people don't appear in front of us anymore.
That's correct.
And for the people, and of course we've got 2 people in the audience, we have no idea who these people are. We have no names or nothing.
Actually, Mr. President, can we take a 5-minute recess real quick? I need to discuss something with
We'll take a
Mr.
vote on this.
Yes, if we could.
Got a motion pending on the floor.
Yes.
The board will recess for 5 minutes. Do I need to repeat that, Ms. Mosley? Our 5-minute recess is concluded, and we will reconvene and recognize Mr. McDonald for further discussion on item number 12.
Thank you, Mr. President. In speaking with Mr. Gribble, it appears that there has been some discrepancy in these last 2 complaints as far as the cremation authorization forms go. And so what I would like to do is remove the violation of the cremation authorization form in this case, but as far as everything else goes that was presented, I would like to keep that in the legal report as violations. And so I think at this point I would recommend that you all make a decision on this. What is this, number 12?
Yes, sir.
On number 12. And then I'll have further statement after that about number 11 in this case.
So in item number 12, we will strike the material containing, having reference to the missing file for a cremation. And was that one file, Mr. McDonough?
Yes, it's that one file
That one file.
regarding Joyce Dupree.
But we still have a consent order with a $2,000 civil penalty. Mr. Hinkle, does that change your motion in any way?
No.
Mr. Patterson, does that change your second in any way? Any further discussion? Everybody understands we are taking out the cremation of Joyce Dupree, but we are staying with the consent order and $2,000 civil penalty with authorization for a hearing. All in favor, say aye. Aye. Any opposed? Motion carries on number 12. We will now revisit complaint number 11.
Thank you, Mr. President. Number 11, it's the same situation, and I would like to strike the issue regarding the cremation authorization forms. I believe there are 4 in that case. But everything else that was presented, I would like that to stand, in this legal report, and I believe that the civil penalty was based mainly on the 34 funeral services that took place while the establishment had an invalid funeral establishment license, and there was also another violation for the current license of the crematory utilized by the respondent. And so I believe that in this case the $3,500 would still be appropriate, but it's up for you all to decide whether or not you would like to change that or not.
May I ask a question?
Yes, ma'am.
Was the establishment notified that their license was, or lack thereof, was in violation, or did they just discover it? Were they sent notice that their license was not been renewed?
They're sent a notice about the 20th to 25th of the month after the license expires. If a license, in this situation, the license expired June the 30th, on about July the 25th, they would have been sent a notice. We get a letter that's pre-printed that we send to them for all that does
For approximately
not respond.
30 days, approximately.
They're, and the reason that it's not sent to begin with is because sometimes they're in the mail, and they get here, so that's the date that their technical people have determined the letter should go out. It's sent over to us about the 20th day of the month.
But then it took them another,
I think I hand carry mine up there.
wait, where's mine? So June the 30th it expired. They got the letter. The letter was noting to them that the violation was sent the 25th of July.
Approximately. I mean,
And
if
they
they mailed on the
and then
20th,
they didn't
21st.
renew their license for another month.
After that.
What size funeral home are they?
Did 34 calls in 2 months.
So
Is it a corporate?
Less than 2
Not mom
months.
and pop.
it's a single operation.
Well, the only reason I was asking that question was, I know some funeral homes, you like Federated and what have you, and they send out checks once a month. Is it a possibility that, of course, I think if it'd been me, I'd have hand carried a check up here the next day, but I don't know where they're at. But I do know some don't write checks. They have somebody that does them for them, and they might do them at the end of every month. So I'm wondering if that could have some bearing on it.
Well, you've heard me say this before, and it's no different than your water bill and your light bill. Just because you don't get a bill or a notice, don't mean you
Yeah. Well, they would
excuse for
notify.
not paying it.
So they,
But, and when you talk about licensings and stuff like that, you know, this board is a whole lot more lenient than a couple of licenses I hold with the state of Tennessee. Is if I let them lapse, it's more than coming from this board and begging forgiveness. Who made the motion?
We are revisiting item number 11. We have already moved on that item. Consent order, civil penalty $3,500, and authorization for hearing. Legal counsel has asked to reconsider item number 11, and counsel wishes to remove the complaint and the response about the 4 cremation files being absent. Council also continues to recommend consent order, $3,500 civil penalty, and authorization for hearing. Is that right?
That's correct.
With that in mind, what is the will of the board?
make a motion to accept council's recommendation on the revised number 11.
Second.
Mr. Starkey makes motion to accept the revised recommendation. Legal counsel number 11, multiple seconds. I think Mr. Patterson on record is second. Any further discussion? All in favor say aye. Aye. Any opposed? Motion carries. Thank you, Counselor, for your report.
Thank you, Mr. President.
Chair will now recognize Mr. Robert Gribble, Executive Director, for his administrative matters report.
Thank you, Mr. President. Good morning, board members. The first report is a report of licenses administratively approved by the Executive Director pursuant to the Board authority for the period of December 11, 2012 through February 11, 2013. And you will see there the establishments and individuals who have been approved for licensure. Next report is a closed establishment report. We have one establishment, Cremation Society of Tennessee, Mary County, 2120 Circle Drive in Columbia, has reported closing since the last board meeting. The third item is the disciplinary action report. This is a report of consent orders administratively accepted and approved by the Executive Director pursuant to the Board authority for the period of December 11, 2012 through February 11, 2013. And also in that, you will notice that I also included an action taken by the board so that there's a record of that made in the minutes of the meeting. So there is one in there that I did not administratively approve, but it's still disciplinary action of the board. Actually, this report is based upon the disciplinary action that's reported to the department taken by this board during that time period. The others were ones that were accepted as the director for the board. And we have an unusual one, suspension of license for failure to pay the payments or the repayment plan for a student loan. For some reason, we've had a unusual amount of those on the funeral board and on the burial services side recently. Because on this report on the funeral side, there's one for suspension of student registration for non-compliance of an order of child support. So that's something that's affecting the licensees. Legal counsel can tell you more about that if you have questions, but it's not anything that once it's reported to us that they fail to make the payment or made satisfactory arrangements for child support or repayment of student loan, the laws of the state of Tennessee require us to immediately suspend their license. It's not anything that the board has to do. It's just automatically done, and then it's reinstated once they work that problem out with the agency, with the child support agency, or with the student loan people, and then they report to us then that we can reinstate their license. So anyway, there's been a rash of that lately.
I didn't know that you could do that. I didn't know that
It's not a situation a funeral director or an embalmer wants to find themselves in, because I know this one, it was suspended, and then she was 2 or 3 weeks getting it reinstated. A couple of weeks anyway. So it's not, I would just encourage the funeral director and embalmers to stay current on their child support and their student loans, because it's not a situation you want to find yourself in.
Scribble, does that come to your office more or less as a court order to suspend those licenses?
It's
Or is it just
not exactly a court order. It's a order by the child support agency. It says an order to terminate what it says, and they certify to us that such and such person is behind on their child support, or such and such person has failed to repay their student loans. The child support has to be in excess of $500, I believe, or the student loan has to be in excess of $500. I've forgotten. Anyway, it's not just like if you miss one payment, you're going to get your license suspended. It's a set amount of money by statute that's.
Are these licenses reissued once it's met, or how does that?
Yes, once they, of course, they call us, complaining to us, and the letter that we send to them is very specific as to who they need to contact and what agency they need to contact and resolve their problem with that agency, because we can't do anything until that agency sends us another written communication saying to reinstate the license. But out of the ones that we have suspended, only one, which is the funeral director and embalmer that's reported on this report here today, is the only one that has theirs reinstated. The others have not made arrangements to get theirs. Some of the others have been on the burial services side with pre-need sales agents. And what we do, just so the board knows, when we suspend one of those licenses of an individual, we also notify their employer, or the employer that we have on record as to who their employer is. And we've been told with some of the employers they no longer work for us, but whatever employer we have on record, for that person, we notify them so that they don't allow them to continue to practice without being properly licensed.
Now, is your website, can I go on the website and see if like my license had been suspended?
Yes.
That's what I thought.
Yes.
We had that, because the other board, the other things that I'm on, we can do that.
And as far as the open complaint report, there are 122 open complaints you'll see on your printout there that Ms. Mosby has provided for that. 6 of those being funeral record and embalmers, and 116 of them being funeral establishments. And just as a way of information, supposedly next month, we'll be meeting over in the other building over in David Crockett Tower, and we'll be in the renovated boardrooms over there. Mr. Highsmith, Mr. Hinkle, and Mr. Starkey and I walked over there today before this meeting, looked at them. They're very nice rooms. The camera and the microphones are supposed to be much better so that the public can view the meetings with more clarity and more understanding of what's taking place once they're put on the website. Ms. Mosby is going over tomorrow for training about how to operate the AV equipment and things like that. So if nothing changes between now and next month, we'll be meeting over at the other building. We will attempt to get reserved parking for the board members over there. However, there will be more than one meeting occurring at the same time on most occasions, so the parking may be a little bit harder to come by than what it has been at this building.
I thought you had valet parking on there.
Valet parking. That would be nice, wouldn't it?
So now, will all our meetings be over there?
Yes, yes. It's my understanding, and what I've been told, that even meetings later on this month are going to occur over at that other building and not in this building. And I know Bureau of Services has a formal hearing scheduled for March the 5th, and we've been notified not to use this room, but to use one of the rooms over in the other building. So, as you came in today, you may have seen a supply truck out back with sheetrock, different things on it. So they're doing some renovations to this building as well. So
Now, you're moving your office.
eventually we're going to be moving the office back over to the other building, but that's to be, my understanding, that's going to be July or sometime like that, because they're still renovating that other building, some floors of it. But these boardrooms are about 99% completed. I will mention that something we noticed this morning, the microphones over in the other boardroom, in the new boardroom, are sound activated. So when you speak, you're going to be heard. Whether you want to be or not, evidently that's the way it appeared this morning, that when you just motion and sound activates the microphone. Because there's a little light on you. At least you'll know when you're being recorded, because there is a light that shows up in red.
I can imagine what it's going to be like when we start coughing.
But Mr. President, that's my report unless someone has a question.
But on this disciplinary report, I want to be sure I understand. On this report means that these people have met the requirements of and the terms of the violation. Is that correct?
That's correct. They have signed the consent order and paid a civil penalty for what the board is authorized to be done to them as for a violation. That was the one that said that where the board made that decision on the one respondent that I've included, where we had the formal hearing and hearing costs is added. That was the board's decision, and I didn't, as I said there in the disclosure, I did not accept that. That was one. It was, that's a situation where there's a hearing, and the board laid out that for the person. That's a report, actually a report of all the disciplinary action for the month of December and January, for the Board of Funeral Directors and Embalmers.
Thank you for Mr. Gribble. We will now advance to the approval of license applications.
Mr. Highsmith.
I'm sorry.
We need a motion on the report.
Is there a motion to accept Mr. Gribble's Executive Director report?
So moved.
Ms. Sowell, seconded by Mr. Neal. All in favor, say aye. Aye. Any opposed? Thank you. Mr. Gribble, we'll now move to the approval of license applications. Do you have any to present to us?
Yes, we have one person, Trina Jones Mueller, is applying today for a funeral director and embalmer's license. Ms. Mueller has been notified that the board will look at TCA 62-5317 and other pertinent statutes and rules regarding the determination about her license approval.
Ma'am, as we look over your application, will you state your name for the record, please?
Yes, my name is Trina Jones Mueller.
Thank you. Could you give us a moment, please, to look over your application?
I'm going to miss that.
Near the end of your documents that's scanned and put on the iPad for you, you'll see a letter from Jeff L. Duffer, who is the National Market Manager for SCI Tennessee Funeral Services, LLC. And Mr. Duffer called and spoke personally with me, and he said he had a prior commitment, and that was the reason he could not be here today, so he wrote this letter, and we received it on January the 18th. But he wanted us to, he asked me to specifically point out that he had written a letter with some details about Ms. Mueller.
Motion to approve.
Second.
We have a motion made by Mr. Starkey, seconded by Mr. Hinkle, to approve Ms. Mueller's application for funeral director's license and to approve her application for embalmer's license. Is there any further discussion? Hearing none, all in favor say aye. Aye. Any opposed? Motion carries. Congratulations, Ms. Mueller.
Thank you, ladies and gentlemen.
You'll see Ms. Mosby if she can help you with what needs to be done from this point. Mr. Gribble, are there any other individual or establishment license applications come for the board at this time?
No, sir, that's all we have today.
Is there any other business to come before this board at this time? If not, the chair will entertain a motion to adjourn.
Make a motion.
Mr. Starkey,
Second.
Ms. Taylor, all in favor say aye. Aye. Motion carries. Meeting is adjourned.
Oh, yeah.